everyone, I'm Suchitra. We are pleased to launch the YouTube channel Easing Law, your window to diverse branches of law. Through this exclusive channel, we bring to your fingertips quality lecture and tutorial videos on diverse branches of law, primarily intended for law students, academicians, practicing advocates, and junior judges. This channel is meant for all of you who have a vocation for this highly volatile and interesting subject called law. The presentations are done by a select panel of the most outstanding yesteryear judges of high courts, trial courts, academicians, and advocates who talk from their rich experience, tempered with vast knowledge they have gathered through years of hard work and dedication. Our purpose is to make this treasure house of knowledge accessible to one and all. We are extremely proud to launch our venture, Easing Law, with a tutorial presentation by one of the most erudite and respectable judges of the High Court of Kerala, Justice Sri V. Ramkumar. Reputed for his classy judgments, excellent judicial craftsmanship, and analytical skills, Justice Ramkumar served the High Court of Kerala from the year 2004 till he retired in 2012. Justice Ramkumar took his law degree, LLB, from Government Law College, Mumbai. He enrolled as an advocate and started practice in the High Court of Kerala in the year 1979. After 9 years of dedicated practice, he was directly appointed from the bar as district judge and served in this capacity in various judicial stations in Kerala. Justice Ramkumar was additional director of training for 1 year at the then Directorate of Training, the present Kerala Judicial Academy. Justice Ramkumar was elevated as Judge, High Court of Kerala in the year 2004. He has pronounced several landmark verdicts. Some of his judgments stand out for his artistic flourishes, which he depicted by sketching diagrammatic illustrations. Single window reference judgments of Justice Ramkumar are well appreciated by legal fraternity. After retiring from High Court, Justice Ramkumar served as Chairman of the Advisory Board under the Kerala Anti-Social Activities Prevention Act 2007 for 3 years. From 2017 onwards, Justice Ramkumar is serving as Ombudsman for Kerala Cricket Association. This appointment is in compliance with the recommendations of Justice Lodha Committee constituted by the Supreme Court of India. Justice Ramkumar is frequently invited by the Kerala Judicial Academy for taking classes for judicial officers, police officers, public prosecutors, and also under the auspices of Kerala Bar Council. He takes classes for advocates too. His articles on various branches of law are held in high esteem, and they are mostly published in www.livelaw.in. And this is held in high esteem by the bench and the bar throughout the country. We are launching Easing Law with the tutorial presentation of Justice Ramkumar on the topic Law of Confession in Criminal Trials. We have recorded this in 5 modules. The first module will give you an overview of the law of confession. The second module will specifically be on Section 24, the third on Section 25, fourth on Section 26, fifth on Section 27 and 30 of the Indian Evidence Act. Students interacting in these sessions are V. Arvind Rajagopal, Shirag Jindal, Abhishek Lajwani, and Ms. Purnima Nair. Thank you.
Good afternoon, friends. The topic for discussion today is the extent of admissibility of confession in the criminal trials in our country. I am not an expert in criminal law. I am still a toddler in law, particularly criminal law. Even today I am baffled by the intricacies of law. Probably those of you who are following the live law, following me in the live law, would have noticed that even after retirement I have reviewed one of my judgments through my article, saying that I was wrong. So that is my approach to law. I don't consider judges to be infallible. They are also prone to mistakes. Only thing is they should be fair enough to concede that. That explains the review petitions and recall petitions before the High Court and Supreme Court. I am only a facilitator who is willing to share his experience with you, and in return expecting lot of things from you also. I do not believe in long lectures, giving an abstract lecture on a topic of law, which may be interesting for the listeners, but after the lecture they just simply forget about that. My methodology is different. I have a feeling that any law is better understood if applied to concrete fact situations, so that you learn the applied law. You apply the law to a fact situation, which I have devised certain questions, so that these are the usual problems which crop up for resolution before our courts of law. Therefore, if you apply the law, you get to learn the law better. That is my methodology. Shall we pass on to the questionnaire? How can confession be classified? First question. How can it be classified? See, basically there is a broad classification. Judicial confession and extrajudicial confession. Confession can be broadly classified into two: judicial confession and extrajudicial confession. Judicial confession is the confession which takes place inside the precincts of a court or a magistrate, whereas extrajudicial confession takes place outside the court. Instances of judicial confession are in judicial confession during investigation, taking place outside the court, and judicial confession during trial, which takes place inside the court. Both are judicial confession. Then we come to the extrajudicial confession, totally outside the court premises. Now coming to judicial confession during investigation, you all know that a magistrate is given the power to record a judicial confession. Now the power given to the magistrate to record a confession during investigation is available under section 164 of the CRPC. That gives the power to the magistrate to record a confession. Now can a confession be recorded by a magistrate of an accused person who simply walks into the magistrate's court and asks the magistrate, my confession may be recorded? Can the magistrate record the confession, or should the accused be sponsored by the police? There is one question which has been baffling our courts. Please take it that if it is an accused, he need not be sponsored by the police. He can simply walk into the magistrate's court and tell the magistrate, see, I am an accused in an ongoing investigation. My confession may be recorded. Only rider is magistrate should verify whether he is the accused, and number two, whether an investigation is in progress. If these two conditions are satisfied, magistrate can record the confession even without being sponsored by the police. Whereas in the case of a witness or victim, unless sponsored by the police, the magistrate cannot record their 164 statement under section 164 CRPC. That is now the provision is 164 during investigation outside the court, and inside the court, what is the confession which could be the confession taking place inside the court? Can you conceive of a situation where the accused confesses before the court during trial, at any stage during trial? Examination is at the fag end of the trial. 313 examination. 313 examination is at the fag end of the trial. At the beginning of the trial. In fact, trial begins only with this. After the appearance of the accused, if it is a summons case or a summary trial case, the particulars of the offence have to be read over to the accused, and accused will have to be asked whether he pleads guilty or not. If it is a warrant trial or session trial, the accused will have to be asked whether he pleads guilty or not, or he claims to be tried. In the case of summons and summary trial, there is no framing of charge. Only the particulars of the offence will be read over to the accused, and his plea will be taken. If he voluntarily pleads guilty, magistrate can straightaway convict him and pass a sentence according to law. Likewise, if it is in his warrant trial or session trial, if the court accepts his plea and the court is of the opinion that the plea is voluntarily made, court can straightaway convict the accused for the offence. This is the confession taking place inside the court, confession taking place during trial. So we have seen confession taking place before the magistrate outside the court. Outside the court means during investigation. Trial is not started. And confession taking place during the course of the trial. In fact, it is only after the framing of the charge that trial starts in a warrant case and sessions case. The trial starts only with the framing of the charge. Now we come to the provisions are, during trial, plea of the accused is taken in a summons trial under section 252 CRPC, in a warrant trial under section 241 CRPC, and in a sessions trial 229 CRPC. But then Kerala High Court has taken the view that in a sessions trial, though section 229 enabled the sessions judge to convict the accused on being satisfied that the plea is voluntarily made, session judges should not ordinarily convict the accused because the offences are grave offences. The punishment is also very stringent. Therefore, instead of straightaway punishing him, instead of straightaway convicting him, the session judge would do better if they call upon the prosecution to prove the case. You may be aware of section 58 of the Evidence Act. An admitted fact need not be proved under section 58. Even there you get a proviso. Notwithstanding the admission, court can call upon the other party to prove the case, notwithstanding the admission by the other party. Therefore, likewise, notwithstanding the plea of guilt, if the offence is grave offence and the punishment is stringent, the session judge need not accept the plea, and he can ask the prosecution to prove its case. This is judicial confession during investigation and during trial. Now we come to the second limb, extrajudicial confession. Judicial confession, as the word itself denotes, it takes place outside the court premises and not before a court, not before a judicial authority. It takes place either before a police officer or before a person in authority, or it can be before a friend or relative. These are all confessions taking place outside the precincts of the court without the involvement of any judicial authority. Now, in the case of police and persons in authority, officers in authority, such extrajudicial confession should conform to Section 24 of the Evidence Act. Section 24 of the Evidence Act says, if the confession made is hid by threat, inducement or promise, if the confession is obtained by employing threat, inducement or promise, it is no confession in the eye of law. So it is applicable to police officers. In fact, apart from Section 24, Section 163 CRPC also, 24 Evidence Act and Section 163 CRPC also lays down the same principle, that if the confession made to a police officer is hid by threat, inducement or promise, it is no confession in the eye of law. That confession is inadmissible, totally inadmissible. Likewise, a confession made before a customs officer or a non-police officer, who has got the authority to record a confession. Excise officers. All those officers have got the authority to record a confession. They are not police officers. But if they record a confession by employing threat, inducement or promise, then that confession is no confession in the eye of law. It is inadmissible. Cannot be looked into. Then the last category is the confession before a friend or relative. Confession before a friend or relative, if courts will ordinarily be cautious in accepting such confession because he may be masquerading as a friend or relative, but he may be having some ulterior motive in getting this person convicted. So courts will have to be very cautious in accepting an extrajudicial confession from a friend or relative. Court will have to be satisfied that he has no ulterior motive in implicating this person and it is free from blemishes. Confession is free from blemishes. With this background and with this classification regarding confession, we now approach the questionnaire. Second question. What is a confession and when does a statement amount to a confession? What is a confession? And when does it amount to a confession?
So, as far as Indian Evidence Act is concerned, there is no perfect definition of confession has been provided under the Act itself. But as far as, if I see in a personal level, it means that admitting to something which a person has done or admitting to a charge or accused or something like that.
You are almost right. Confession means the admission of the ingredients of the offence. Admission of the ingredients of the offence or substantially the facts constituting the offence. Admission of the facts constituting the offence or the ingredients of the offence. That is what is called confession. So confession is an admission. While all confessions are admissions, all admissions are not necessarily confessions. An admission, in order to become a confession, should admit to the ingredients of the offence or substantially the facts constituting the offence. The facts constituting the offence are admitted, you can call that admission a confession. Otherwise, it is no confession. This beautiful definition was, courts in India were taking very, very different views. Ultimately, the Privy Council, consisting of 5 law lords, presided over by Lord Atkin, gave the classic judgment in Pakkala Narayana Swamy versus R. AR 1939 Privy Council 47, wherein they gave this definition. In order to become a confession, the admission should be that of the ingredients of the offence or at least the facts constituting the offence. Beautiful definition. It was approved by the Supreme Court in AR 1952 Supreme Court 354. Again AR 1960 Supreme Court 409. We pass on to question number 3. Is oral confession by an accused person evidence within the meaning of section 3 of the Indian Evidence Act? You almost gave the answer to this question. Evidence Act defines the expression evidence. What does it say? Evidence Act. Section 3. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. So, statements by witnesses. 2. All documents including electronic records produced for the inspection of the court. Such documents are called documentary evidence. So, evidence definition takes in only oral evidence of witnesses and documentary evidence in the form of documents or electronic records. Confession does not fall under that. Then where will you place confession? Under the Evidence Act. Courts can rely on confession, and even courts have taken the view that a confession, if it is otherwise admissible, otherwise reliable, it can form the sole basis for a conviction. So confession can be the sole basis for a conviction. It is not evidence also. It doesn't fall under the definition of evidence. You will find the definition of the expression proved in Evidence Act. A fact is said to be proved when, after considering the matters before it, court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstance of the particular case to act upon the supposition that it exists. See the beautiful definition of proved. So after considering the matters before it, confession falls under the expression matters before it. Likewise, supposing the presiding judge wanted to see the place of occurrence, wanted to personally inspect the place of occurrence, he can inspect the place of occurrence, prepare notes. That notes does not become evidence. Confession by an accused, notes prepared by investigating officer, then answers given by the accused during 313 examination. These are all not evidence strictly speaking because they don't fall under section 3, evidence, definition of evidence. But they are all matters falling under the definition of the expression proved. It is all after, likewise material objects. Material objects is not evidence. Evidence definition does not take in material objects. But you find so many material, especially in criminal cases, you find so many material objects being marked, exhibited and marked. MO1 chopper, MO2 sword, MO3 knife. All these material objects are marked, but they are not evidence. They don't fall under the definition of evidence. But they fall under the expression matters under the definition of proved in the Evidence Act. Therefore, that is how the court, while evaluating the evidence and the matters before it, court can even rely on the confession for recording a conviction against the accused. So, it's, technically speaking, the answer is it is not evidence under section 3 of the Evidence Act, but then it will fall under the expression matters within the definition of the expression proved in Evidence Act. I will give you the citation. AR 1964, Supreme Court 1184, 5 judges. Again, AR 1952, Supreme Court 159, 3 judges. Question 4. Where a part of the statement of the accused by the accused is inculpatory and another part exculpatory, is not the prosecution entitled to request the court to use the inculpatory part of the statement? See, a statement. The accused admits that he stabbed the deceased. He admits. But I stabbed it in exercise of my right to private defense. So he is admitting the act causing the death. He also says this was done by me in exercise of the right of self-defense, private defense. So the prosecutor argues before the court, here is a person who has admitted that he has committed the murder. No. You can't take that statement. You cannot dissect the statement. You cannot take a part of the statement. You cannot sever the statement into the part which is required. You have to take the entire statement as a whole. So the exculpatory part, that is which excludes him from liability, and the inculpatory part which incriminates him, this will have to be taken together. Court or the parties cannot make a dissection of the statement. That is the law on the point. The citations are AR 1966, Supreme Court 119. The inculpatory part alone cannot be used by the prosecution or the court. Court has to take the entire statement as a whole. It cannot dissect the statement into two and allow the prosecution to take the relevant portion or allow the defense to take the relevant portion. Entire statement has to be taken as a whole. Question 5. A confession is recorded by an executive magistrate under section 164 CRPC. Is it totally inadmissible? An executive magistrate records a confession under section 164 CRPC. Now you know under section 164 CRPC the magistrate can record a confession only if he is satisfied that the confession is voluntarily made. Voluntarily made means knowing fully the consequences of the confession. So when an accused walks into the magistrate's court and says that I want to make a confession, as I told you, he need not be sponsored by the police, unlike a witness or victim. So the accused can say that I want to make a confession. Magistrate will not straightaway record the confession. Magistrate will have to be satisfied that his confession is voluntarily made. So magistrate will tell him, see, you are making a confession of an offence. The punishment prescribed for the offence is this. Even imprisonment can be awarded by me. I can even award the maximum sentence on you. Just because you confess before me, don't expect any leniency. The law allows me to even award the maximum sentence. Therefore, you are not bound to confess. If you are confessing on the strength of some extraneous influence or somebody's influence, please note that you are in a trouble. You are in real trouble. Don't confess. You are not bound to confess. These are all the words of the magistrate. He has to inform the accused that he is not bound to confess. Section 164, if you read section 164 clause 4, these words are there. Even the words which the magistrate should speak to tell the accused are there in section 164. If in spite of that he maintained that no, I know the consequences, I am confessing without any extraneous influence, nobody has influenced me, I am prepared to confess, I am prepared to take the consequences, whatever may be the punishment, voluntary confession. Normally magistrates give them time for reflection. Normally magistrates will give the accused some time for reflection. Let him reflect over the confession. So he will ask the accused, you come tomorrow. You come tomorrow, think over it. You have my words in your mind. And you are not bound to confess. Even if you confess, don't expect any leniency in the sentence. I may award the maximum sentence. Therefore, please don't confess. He is allowed to go home, reflect over it. Even after reflection, if he comes the next day and says, I have thought about it, I am prepared to confess, I know the consequences, then only the magistrate will record his confession and convict him. So here is a case where an executive magistrate, that is a sub-collector or an RDO, he is recording a confession under the section says judicial magistrate, is it not? 164 says judicial magistrate. Now an executive magistrate records a confession under section 164. Is it good or bad?
It is not going by the section, it is not admissible.
Certainly. You are absolutely right. It is totally without jurisdiction. Executive magistrates are not given any power to record a confession under section 164. Mind you, under section 164. But he can definitely record an extrajudicial confession. Definitely, he can record an extrajudicial. But if he wants to record a confession under section 164 CRPC, he has total lack of jurisdiction. He cannot. That has been so held by the Supreme Court in AR 2000 Supreme Court 2901. Question 6. During the investigation stage, the accused person appears before a magistrate and voluntarily offers to make a confessional statement. The APP present in court tells the magistrate that unless a request in that behalf is made by the police, the magistrate cannot record the confession. Ignoring the submission of the APP, magistrate records the confession after following the procedural safeguards under section 164 CRPC. Is the magistrate correct? Is not the magistrate correct? Or is he wrong? Has he committed an illegality in ignoring the caution given by the APP?
No, sir. So he is correct because unlike the victim and the
Exactly.
Unlike the victim and the witness, the accused might not be always sponsored by the police.
Not always. Invariably, he need not be sponsored. He has the liberty to walk into the magistrate's court and tell the please record my confession. I am an accused. Investigation is in progress. And if the magistrate is satisfied that he is an accused and investigation is in progress, he is bound to record the confession. Nothing more, nothing less. Therefore, the APP was not right and the magistrate was fully correct in doing that. AR 2001 Supreme Court 2503 Mahavir Singh versus State of Haryana. See, when we apply the law to concrete fact situations, you get to learn the law better. That is my methodology. I don't know whether I am right or wrong. It is for you to decide. It is for the viewers to decide. Yes, please.
So it is necessary that the person making the confession must be an accused person.
He has to be.
Or at least a suspect.
He has to be an accused.
So how can...
And an investigation should be on. There should be an investigation going on.
So there is no provision which governs a person who is not an accused. Out of his conscience, he can still come to confess before the magistrate. Is it governed? Is that situation governed?
In that case, magistrate will say, why do you want to confess? You are not even an accused. Even if you are an accused, you are not bound to confess. So you are not even made an accused. Why should you want to confess? If you want to make your conscience clear, do it to your mother or father. Why do you waste my precious judicial time? Even if you are an accused and an investigation was in progress, you are not bound to confess. I will tell you not to confess. That will be the answer.
Wouldn't that be against the ends of justice?
It's not a question of justice because he is only a suspect. He is not yet made an accused. Why should he worry? A suspect need not worry unless he is made an accused, unless an FIR is registered against him. Supposing an FIR is registered against him, of course, very serious consequences follow. But when there is no FIR registered against him, why should he worry?
What if in a circumstance where there is an unsolved crime? It's an unsolved crime.
Yes.
They are not able to fight. They are not even able to make out a suspect. Because of that reason, the police are not able to find the suspect at all. After 10 years of...
He can go to the police and confess. He can go to the police and confess. See, you are all groping in the dark regarding the offender. I am the offender. He can go and confess. But then he will have to face the music. That's all. But precious time of the court will not be wasted. Courts have other business to do. Question 7. Is there any difference in the case of a witness or victim? We have seen that. In the case of a witness or victim, unless sponsored by the police, their statements under section 164 cannot be recorded. The citation is AR 1999 Supreme Court 2565. Again, AR 2013 Supreme Court 633. We pass on to question 8. What is the impact of testimonial compulsion envisaged by Article 23 of the Constitution of India on the following? Narco-analysis, 2. Polygraph test, 3. Beep test, 4. Collection of specimen signatures, 5. Collection of handwriting samples, and 6. Collection of bodily substances. What is the impact of testimonial compulsion? What is the testimonial compulsion under the Constitution? Under Article 23. What does Article 23, Clause 3 of Article 20 say? No person accused of an offence, shall be compelled to be a witness against himself. Testimonial compulsion. Self-incrimination. Is it not? No person accused of an offence shall be compelled to be a witness against himself. There are 6 tests given. These tests are done by the police during the stage of investigation. Can a person be subjected to these tests, and will the conduct of these tests violate Article 23 of the Constitution is the question. Narco-analysis, polygraph test, beep test, collection of specimen signatures, handwriting samples, bodily substances like blood sample, etc. First 3 stand in one class, latter 3 another class. First 3, what is the effect of first 3? Either truth serum or he is subjected to some medico-legal examination. He is subjected to certain tests and asked to make a statement under trance or under a particular serum, is after administering a particular serum. Now the beautiful test laid down by 11 judges Constitution bench in State of Bombay versus Kathi Kalu Ogad, the celebrated case, 11 judges, is that if the test has the effect of conveying the accused, the suspect's personal knowledge regarding the charge, conveying his personal knowledge regarding the charge, then 23 is offended. You are compelling him to be a witness against himself. But if on the contrary he is only asked to furnish evidence like blood sample or signature sample for comparison, You are not compelling him to be a witness against himself. This is the beautiful test laid down by Kathikalu Ogad's case, 11 judges constitutional bench, which was again followed by a 2 judges bench in Selvi versus State of Karnataka, where these tests were held to be illegal unless they are conducted with the consent of the accused. Unless the accused consents these tests, he cannot be subjected to these tests. Then question 9. Can the accused be called upon by the court to produce documentary evidence in his possession which throws some light on the controversy? Accused is having some document which if produced or if compelled to produce will incriminate him, or which will have some serious consequence on him with regard to the charge he is facing. He is compelled to produce a document. Now, if you go by the 11 judges constitutional bench decision in Kathikalu, unless he cannot be compelled to produce the document if it has the effect of conveying his personal knowledge about the averments in the charge, allegations in the charge. Otherwise, he cannot. There is no bar in compelling him to produce the document. That is the impact of, or rather, that is the ratio decided laid down in Kathikalu Ogad's case. But then, strangely enough, a 5 judges bench, this is 11 judges, Kathikalu mind you, a 5 judges bench in state of Gujarat versus Shyamlal Mohanlal, AR 1965 Supreme Court 1251, came to the conclusion that true, Kathikalu Ogad is a 11 judges constitutional bench, but then Kathikalu Ogad did not examine the provisions of law under the CRPC by which an accused person can be compelled to produce a document. Section 91 CRPC, of course it was, old section was 94 or so, 94 old section, it is 91 now. Section 91 of course is the provision which enables the court or a police officer to compel an accused person to produce a document which is in his custody. This provision was not considered by the 11 judges constitutional bench. So the 5 judges bench in Shyamlal Mohanlal's case held that he cannot be compelled to produce a document because even if it does not incriminate him, even if it is not incriminating him, he cannot be compelled to produce a document because true, section 91 enables the court or the police officer to compel him to any person. Section says any person, so it includes an accused person also. But then under section 389 CRPC, on failure to produce document, there is a power in the court, in the magistrate or session court, to conduct an inquiry and to find out whether the failure to produce the document was justified or not. Whether he was justified in not producing the document. He can withhold the document and offer reasonable explanation for withholding the document. The Shyamlal Mohanlal's case, constitutional bench 5 judges held that this power is given only to the court, even though the enabling provision under section 91 gives power to the police officer as well as to the court to compel a person, an accused person, to produce a document. In the event of non-production, court alone is given the power to conduct an inquiry, because inquiry police have no power to conduct inquiry. Inquiries are all conducted by the police. It is only for the first time that the judge-made law of conducting inquiry was introduced by the Supreme Court in Sirajuddin's case, in corruption cases. Otherwise, inquiry is totally foreign to the police department, to the police officers. Inquiries are always conducted by the courts. Therefore, the Shyamlal Mohanlal constitutional bench said, since the court alone has got the power to conduct an inquiry and ascertain the view of the accused, police officer does not have the power to conduct an inquiry. If you give the power to the court alone and if you deny the power to a police officer, this will result in discrimination. Therefore, total ban. Court and the police officer will not compel the accused to produce any document, whether it incriminates him or not, whether it will convey his personal knowledge regarding the charge he is facing. This is the view taken by, of course, in my view, it requires reconsideration. Even Kathikalu did not go to that extent. This is the view taken. Then we pass on to question number 10. Is the power under section 91 CRPC available only to a court? No, it is available to a police officer also, going by the section. But then contributed by Shyamlal Mohanlal says, since police does not have the power to conduct inquiry, you don't exercise that power. Court also don't exercise that power. Very harsh interpretation given. Anyway, it has stood the law of time. Stood the time so far. No party has sought to challenge it, and if challenged, I think that it will not survive. Question 11. If section 91 cannot be invoked for the purpose of summoning a document in the custody of an accused person, can section 94 be invoked for conducting a search of the place and get at the document? That also was answered by Shyamlal Mohanlal. They said 91 and as well as 94 stand on the same footing, and both cannot be exercised by the police officer or the court for summoning a document in the custody of the accused. Then the next question. If sections 91 and 94 CRPC cannot be invoked for the purpose of summoning a document in the custody of an accused person, what is the way out for the prosecution? There the Shyamlal Mohanlal again said the only way out is to conduct a general search. The general power of search under section 165 CRPC. The police can conduct a general, it has got the general power of search under section 165. You conduct the search under section 165 and get at the document. You don't call upon the accused to produce the document. That also answered by Shyamlal Mohanlal. Then question 13. For the bar against testimonial compulsion under Article 23 to apply, is it not enough that the person subsequently becomes an accused after the impugned statement has been obtained from him? See, the wording is, no person accused of an offence shall be compelled to be a witness against himself. The question is whether at the time when he is questioned, if he is not accused of an offence, or if he is only a suspect, not accused of an offence, will the bar under Article 23 of the Constitution apply? Clause 3 of Article 20, whether it will operate. That is the question. Supreme Court said no. The bar, in order to apply, he should be an accused person. There should be a formal accusation against him, at least in the form of an FIR or in the form of a complaint before the court. These are the two matters on which the court can go into the question. Therefore, at least in the form of a complaint or in the form of an FIR, there should be a formal charge against the accused, formal accusation against the accused. Then only the bar under Article 23 will apply. The result is, if he is only a suspect, not an accused, no FIR is registered, he can be questioned, his confession can be recorded. But then after answering the next question, you will see the relevance of that. I will give you the citation. A year 1961, Supreme Court 1808, State of Bombay versus Kathikalu. Again, 11 judges constitutional bench. The constitutional bench also held that unless he is an accused, formally accused, formal accusation is there, you can't take his confession statement. When does a person become a person accused of an offence within the meaning of Article 23? That is the question. 14. A person against whom a formal accusation has been levelled by lodging an FIR against him. MP Sharma versus Satish Chandra, year 1954, Supreme Court 300, 8 judges. 1954, Supreme Court 300, 8 judges. Again Kathikalu, 11 judges, para 14. Again, year 1973, Supreme Court 1196, 5 judges. Immunity against testimonial compulsion. When does it extend? If he is not formally made an accused, if no FIR is registered against him, no complaint is filed against him, a confession can be recorded, or a confession, if recorded, will not offend clause 3 of Article 20 of the Constitution. So what is tabooed under section Article 23 is forced confession. Forced confession or volunteered confession. Volunteered confession. Question 15. An officer in charge of a police station interrogates a suspect against whom there is no formal accusation. If such a person were to make a confession not resulting in any recovery, will it attract section 25 of the Evidence Act, which envisages only a person accused of an offence? See, as in the case of clause 3 of article 20, section 25 of the Evidence Act also uses the same expression. No person accused of an offence. See, section 25, Evidence Act. No confession made to a police officer shall be proved as against a person accused of any offence. Accused of any offence. Same wording in article 23 also. But here, courts have interpreted this a person accused of an offence to mean that it is not, he need not necessarily be an accused person at that point of time. The person accused of an offence, the expression person accused of an offence is only descriptive of the person. It's only descriptive of the person. It is enough that thereafter he is made an accused. At the time of making the statement, he need not be an accused. He need only be a suspect. But if he is thereafter made an accused, section 25 will be attracted. Therefore, if a suspect makes a confession and if he subsequently is made an accused, that confession will be hid by section 25. That will relate back the subsequent his subsequent implication as an accused or subsequent arraignment as an accused will relate back to the confession, and confession will be tabooed under section 25 of the Evidence Act. Nandini Satpathy versus P.L. Dani, 1978, 2 SEC, volume 2 SEC 424. If I remember correct, by Justice Krishna Iyer, V.R. Krishna Iyer. Nandini Satpathy versus Dani. See the position under Article 23, if he is only a suspect, his confession can be recorded. 23 is not violated, but it will violate section 25 of the Evidence Act, because if he is ultimately made an accused, if the suspect is ultimately made an accused, this confession made to a police officer will be hid by section 25 of the Evidence Act. Question 16. The accused is arrested and produced before the magistrate during investigation of the case. Magistrate, in exercise of his power under section 73 of the Evidence Act, asks the accused who is present in court to give his specimen signatures and handwritings for the purpose of comparison by the investigating agency. Is the action of the magistrate proper? Accused during investigation is arrested and produced before the magistrate. For the purpose of enabling the investigating officer to compare his signature, the magistrate asks the accused to give his signatures. Accused refuses. The public prosecutor in charge of the case says his signature has to be given to the investigating officer for comparison. The court, Supreme Court, took the view that if the magistrate wants the signatures for comparison, for the magistrate himself, because under section 73, court itself can compare the signature. Court itself can compare the signature. But instead of the court comparing the signature, the court wants the specimen signatures for the purpose of comparison by the investigating officer. No, you can't do that. You can't do that. The court can request these signatures, specimen signatures, only for the purpose of the court itself, not otherwise. But now there is a legislative intervention in the form of section 311 capital A. Therefore, this I will give you the citation. 1994 5 SEC 152. 1994 5 SEC 152. That is the citation whereby the Supreme Court said you can't call upon the accused to produce to give his specimen signatures for enabling the investigating officer to conduct the investigation. But you can do that. Court has got the power under section 73. That position is now gone because of the legislative intervention in the form of section 311A CRPC, whereby the court is given the power to call for the signatures, specimen signatures at any time.